cannot be disclosed in public, this can be provided to the committee, either in private or in writing at a later date. However, please be advised that pursuant to Standing Order 111, there are only a few specific circumstances that allow for non-disclosure, which includes national security matters, third-party confidential information, personnel or human resource matters, and committee deliberations and development of committee's recommendation and reports. Ladies and gentlemen, this is a parliamentary meeting and all information gathered is covered under the Parliamentary Powers and Privileges Act. However, please bear in mind that we will not condone slander or libel of any sort, and any information brought before this committee should be based on facts. In terms of the protocol of this committee, please minimize the usage of mobile phones and all mobile phones to be on silent mode while the meeting is in progress. I wish to also remind the honorable members and our guests that all questions that are being asked are to be directed to the chair. To the public who are tuning in today, the committee will be hearing submission from the Ministry of Education on the Education Bill, Bill number 34 of 2025. Briefly, the Education Act of 1966 is foundational law for pre-tertiary education in Fiji, and since its declaration in 1966, the Act has only been amended 7 times. Given that the Act had not undergone a comprehensive review since its inception, it became imperative that such legislation be reviewed and made up to date to modern standards and best practices, and to also address the developing issues and concerns within the education system in Fiji. Honorable members, now I would like to take this time to introduce the members, ladies and gentlemen, I would like to take this time to introduce the members of the committee, the Standing Committee of Justice, Law and Human Rights, the Assistant Minister for Itoki Affairs, furthest to my right, Ratu Iskeli Tueleu. Next to him, former Minister and Member of the Opposition, the Honorable Chone Usamate. Next to him is the Assistant Minister for Finance and Business Development, Honorable Sachida Nand. And just to my right is the former Minister and Member of the Opposition, the Honorable Fayaz Quair. And tuning virtually, ladies and gentlemen, and to the members of the Ministry of Education here, the Assistant Minister for Justice, Honorable Ratu Chose Nyundamu, and myself as Chairman, Ratu Rakuita Bakalalambure. That is the composition of the members of the Standing Committee on Justice, Law and Human Rights. And with us today, honorable members, is Ms. Nayanga, who is representing the Commission. Is my correct? No. Okay. So Ms. Nayanga is here just for the education bill. We have Mr. David Solvalu. Thank you very much for coming in, David. We also have Lian Vaurasi. Welcome again, Ms. Vaurasi. Master Metui. We are members of the committee are familiar with Master Metui. And last but not least, Ms. Biskula. Thank you very much for joining us. Honorable members, these are our submittees this morning. We welcome them on behalf of the Honorable Speaker and the members of the Standing Committee of Justice, Law and Human Rights. I welcome you to Parliament. Thank you very much for coming. And I now call on our guests to make their submissions. And honorable members, with your indulgence, as they go along, it is open to ask questions, because I'm not sure how long they will take. So with your indulgence too, we'll be asking questions as they go through, because if we wait right at the end, it might take too long to come back. I think so we'll just go along with it. Okay. Thank you, honorable members. I will now give it to, okay. David will be taking the lead in making the submission. Is it? Okay. Thank you. You have the floor, David Naka.
Thank you, Honorable Chair. So, in making our presentation, we, because members of the ministry had been accompanying the standing committee on the consultations, so we decided that the best way to make this submission would be to address some of the contentious issues raised during public consultation, and also to provide the ministry's perspective on these issues The current bill is the policy of the ministry, and has been endorsed by cabinet. But in listening, I mean, this is the value of public consultations, right? Listening to the public, there are some areas we think would better need to be clarified, and but also some areas where we see some valid points raised. So we would be willing to provide our perspective on those valid points. So, but please, if there are any particular issues you want us to go directly into right now and just focus on those because they may be of a high priority level for you, Chair, or for your fellow members, feel free to just interject and just let us know, and we'd be happy to address those issues directly. We also, after this, would be willing to provide a written submission which addresses all the issues which we will be discussing. So we'll go part by part as well. For part one, we note the first recommendation for Fiji to consider how New Zealand has set in their New Zealand Education and Training Act 2020, the values that are there, if Fiji could have something reflected similarly, and also the role of the GCC in the education framework. So for that issue, we do note that some of the elements in New Zealand are worth considering, but some are very specific to New Zealand. For example, we do not have the Treaty of Waitangi in Fiji, or an equivalent. We have our constitution, and that's pretty much what guides us. There are also specific Fijian laws that deal with the Itauke in particular and their relationship to the state. For example, the Itauke Affairs Act, but those laws provide for that relationship. In relation to the role of the GCC in the education framework, we are happy with the standing committee as the bill is now before the standing committee and it is within your jurisdiction. I mean, we would acknowledge whatever decisions you make on that matter. We would only point out that in clause 14.1J, the Education Advisory Council is to consist of 10 representatives of controlling authorities with proportionate representation from religious and cultural institutions. So under that clause, there is an avenue for the GCCs to have some form of relationship within the education framework. Although we would note that that would be in relation to controlling authorities, so authorities that actually own schools. So I've been informed that they do own at least one school. I'm not sure of the full number, or have some relationship with the schools, the Fijian schools. So that relationship could be what is strengthened under this provision. Another alternative would be to directly have them as a representative from the GCC directly as a member on its own of the Education Advisory Council. However, the ministry leaves that to the standing committee to make that decision after consultation with the relevant cultural bodies. Sure.
Through you. Thank you, David. Just a quick question, especially along the lines of 14.1, in terms of the Education Advisory Council. I'm not sure if this was addressed before or you've had a look at it. Just your thoughts on the number of the council actually consists of the PS, the Fijian Head Teachers Association, the Fiji Principal Association, School Management Association, the Fijian Teachers Union, and the Fijian Teachers Association. What happens in the case of a body becoming defunct?
Do you mean the case of one of these bodies? Yep. So if one of these bodies becomes defunct, it would depend on the circumstances. If there's an alternative replacement body that carries the same role or function, then there are two options. It would be either an amendment to the act, to the eventual act, or if the body has actual parallel functions, and it's just a replacement of the name of the institution, that could be done by under the revised edition of the Laws of Fiji Act, through the powers of the Commissioner for Law Revision, which has the power to, where names change, office titles change, or equivalent bodies replace, to make those changes in the body of law without returning to Parliament. This is a valid question, but it's a question that exists across a variety of laws that name representatives from institutions. So, to my knowledge, that's dealt with either by way of an amendment when these bodies no longer exist, or a direct amendment by Parliament, or the use of the Commissioner's powers. The second issue we note is in relation to essentially empowering or giving formal recognition to the study of the Itauke language, or teaching Itauke, or the Fijian language. For that, our response to that is that we believe that's sufficiently covered by Clause 23, because it is mentioned specifically, Vosavakaviti and Hindi. Those are mentioned specifically in Clause 23. I think there's been some confusion in the public. There's been some confusion by members of the public around what 23.3 is listing out. It appeared that some are of the view that these are options, the subjects listed in Clause 23.3, but these are not options. It specifically states that the authority must ensure that the curriculum includes these. So under 23.3, C, it includes Vosavakaviti and Hindi, and in 23.3I, it states the cultures and customs of the indigenous people and local communities of Fiji. We also note for part one, some submissions were technical in nature in relation to drafting. So we would just directly address those because we do not see those as errors. For example, there was a submission that the definition of recognized and registered schools are exactly the same, but they are not. The definitions are different. So under Clause 2, the definition of recognized school is a school that has been granted a certificate of recognition under Section 54. And registered school is a school that has been granted a certificate of registration under Section 54. So both these certificates are granted under Section 54, but separate certificates. A certificate of recognition makes you a recognized school, and a certificate of registration makes you a registered school. Other technical things raised include the fact that there's a special definition section for the meaning of school, but that is common drafting practice. In fact, I'm sure the Standing Committee would already be aware of this, as several of the bills before you, the other bills as well, also have definitions in their own sections, including a variety of acts of Fiji. It is standard practice to create a definition, like a specific standalone definition section for a term, if the term includes multiple elements, and they cannot be defined under the general interpretation section because the definition is more complicated than could be captured in a single sentence. So, but those are technical issues that we would like to respond to. In relation to the curriculum as well, sure.
So just clarify, what then is the difference between registration and recognition? If they're two separate certificates, is one a precursor to the other?
Yes, you are correct. A recognized school is a school that may not meet all the requirements for registration, but can function. And this would be employed in, like, for example, rural areas where the full requirements may be difficult to achieve, but the need to ensure that there is access to education sort of is superior to the technical requirements around facilities, etc.
Just a follow-up question on that, David. Is there a specific timeline laid out from recognition to registration?
No, and to my understanding, that could be because a specific timeline would be maybe too prescriptive.
Okay.
The journey from a recognized school to a fully registered school may be different based on the individual circumstances of the school within that area. If it's a rural area or maritime area, it might take a lot longer and be more expensive to transition that school to full requirements.
So Haide is to be flexible.
Yes.
Right? Okay. I'm just worried because there's a lot of schools being opened up recently. Anyway, continue.
We don't want more votovonos with no specialist teachers.
Not to put too much of a finer point on it, but with respect to the particular provision that you referred to earlier on, 23(3)(c), you're talking about the formal learning of Vosavaviti and Hindi. Why is it that when you did this drafting, you didn't use the same language as is what is required in the Constitution? Right? Vosavaviti is what is written in the Act. But in terms of what is written in the Constitution, it says conversational and contemporary itoke. And what is paramount is that it says conversational and contemporary itoke and Fiji Hindi languages shall be taught as a compulsory subject in all primary schools. Now that's what in terms of the right to education, section 21, subsection 3. When we do the bill, when we look at the bill, it's referred to in a different form. It may not to some mean a lot of difference, but there is a lot of difference. Because you're talking about current development and assessment in terms of the curriculum, the national curriculum, and this is a requirement under our Constitution that those two, conversational and contemporary Toke and Fiji Hindi languages, shall be taught as a compulsory subject. We can't run away from that. We can't. So why is it that the description in the Act is not exactly the same?
Thank you, Honorable Member. Chair, so the Constitution will always apply. So the requirement under the Constitution still applies. This does not replicate or remove or replace that requirement. The thing is that they are very different requirements. The limitations...
Can I interrupt you there? I'm sorry, but it does. Because when you refer to the two languages in a different form, it does. Because you're talking about the development of a curriculum for a compulsory subject. If you don't describe it in the exact fashion that it is in the Constitution, it differs. I'll explain to you why. And I'll use the Hindi that is being put into the bill. When you speak of Hindi, there are many different versions of Hindi. When you speak of Itoke, there are many different versions of Itoke. So you have to be very specific in terms of the development of the curriculum and describing it in the bill. I believe that it ought to be exactly as it is. Why is it that it should be any different? I don't know. But just that's the point. There are different versions. So you're going to confuse a lot of people. Yeah? Because of the compulsion issue in the Constitution. It's conversational and contemporary. Yeah? I think you understand what I'm saying.
Yeah, I do. Sorry, let me just clarify. The requirement under the Constitution is for conversational and contemporary Itoke and Fiji Hindi, and that requirement only applies to primary schools. We are doing something different here because what's in this provision is the formal versions of these languages. So that would be Vosavakaviti. It's not the contemporary and conversational version, but the formal version, as well as Hindi, the formal version. So it's doing something different than the Constitution. The constitutional requirement still applies for primary schools and for conversational and contemporary Fiji Hindi and Itaukei. So there will be a need for that to be taught as per the Constitution at primary school level. But for the formal versions of these languages, this is where the bill or the act will go beyond. It is creating a new requirement that the formal versions of these languages are taught in schools, which is not just primary school, but also high school, that it's an option. So the curriculum will, the curriculum must provide for it. That's why it's a bit going beyond the Constitution and adding in new requirements, because we believe that the constitutional requirement is the base requirement and it's already in law. It's in the strongest law in the land. So this is additional to that. This is adding. Yeah, so that's why it's not inconsistent. It's just adding new requirements.
In that case, what about the other minorities? Languages.
For the other minorities, it's a resource issue because what we're creating here in the bill is what must be taught across all schools. So we're only listing the required things that must be taught across all the schools. So we have a lot more faith in the ability to provide the teaching resource for Vosavakaviti and Hindi, but in relation to minority languages or languages spoken by minority populations, that could be set out by the authority, which is the Curriculum and Development Authority, when while liaising with the Ministry of Education, they come to the conclusion that there is sufficient teaching resources to provide for that need. But the one in the bill is what they must provide as soon as it rolls out. So that will be a staggered, once the resources and the experience and expertise becomes available, that may be considered by the authority to make that call in the future. But for now, there is the belief that this should be something that we can provide.
Can I also? Volvina Kasaka. In terms of the constitutional requirement of conversational Vosavakaviti and Fiji Hindi, it is taught up to year 10, but it is not examinable. With regards to the inclusion in the curriculum in the education bill with the formal learning of Vosavakaviti and Hindi, it will be examinable because it will be all across from primary as well as secondary. Vinaka, I hope that clears it out a bit more. Okay, Vinaka.
It does. I understand exactly what you're saying, but we are creating a gray area which probably needs to be explained better or somehow facilitated with a clause saying these things may also, I don't know. It's something that we will have to obviously discuss, but probably need your assistance in when we do discuss that. But it creates an area of not so much confusion, but it will be required in addition to what is being said. Yeah? Thanks.
Chair, if I might just continue from where Honorable Quay has left. Since independence of our education system has been, and correct me if I'm wrong, Hindi and I believe Itaukei has been taught in schools, in some schools, and as an examinable subject. And in other schools where it's run by different ethnicity and others, they have been teaching their own languages. And it has been going for ages. For example, if I can quote, Yat-sen does teach Chinese. And it's not in the curriculum, but they do as their own resource. So I believe the minority languages can be covered, just like in other schools. For example, Muslim schools, they can be taught Urdu. Chinese schools, they can be taught Chinese and others. So, but majority of the population speak these two languages apart from English. And that's what needs to be covered, because a lot of literature is either written in English or in Vosavagaviti or in Hindi. We don't have a lot of literature that is available for the schools in Fijian Hindi. I mean, there is no set vocabulary for Fijian Hindi. There is no set structure for Fiji Hindi. Fiji Hindi is spoken in Lambasa is totally different than Fiji Hindi is spoken in the West. And so what do we set as standards? And what resources do we have? So I believe where conversational Fiji Hindi and E2K is taught and not examinable, that's good because that's for conversational purpose only. But as an examinable subject, I believe Vosavakaviti and Hindi needs to be taught. Thank you. And for the schools, if they may choose to, they can provide alternate subjects. Like, for example, they can teach Chinese in Chinese schools, Urdu in Muslim schools, and in South Indian schools, they can choose to teach Tamil and Telugu, which they do. Thank you.
Yes, you may continue, David.
Thank you, Chair. For the other issues raised around by the public that we've noticed, people have requested that it be included in the curriculum. These are discipline, work ethic, communication skills, problem-solving ability, and ways to more smoothly transition students into the workforce. So for that, we think it's sufficiently covered by Clause 23.3. Civic responsibility, morality, and discipline is listed in paragraph B. Health and nutrition, physical education and sports, music and the arts, and importantly, practical life skills. These cover these things that are being asked for. Also importantly, the cultures and customs of the indigenous people and local communities. The reference to local communities includes non-indigenous. We also note that the bill addresses this in other ways as well. For example, for emotional development and well-being, there's the requirement to provide counseling services under Clause 72. For transitioning to realistic work environments, there is the requirement for heads of schools to take all reasonable measures to ensure that students are provided with appropriate career education and guidance to prepare the students to join the workforce. This is a direct quote from Clause 36. And also the requirement for the Higher Education Commission to provide a publicly available careers information service under Clause 37. So.
I'm sorry, David, if I can just ask a question. Sorry, this is going back to the curriculum. Probably the question will be better directed to the ministry rather than to the drafters. There was a submission that came in Buddha Village. And it was a very good submission. It was pretty fair that rugby be made a compulsory subject. I understand in the curriculum you have physical education and sports, but then currently it's sort of an extracurricular activity in schools. It's not even a compulsory subject. You know, the submission that was made in Buddha was pretty good because rugby now is a source of livelihood for families. It's providing income to the economy of Fiji. They made a valid point. Probably that's why I'm raising the question probably to the ministry. What are your thoughts around that, making it as a permanent subject to be taught? You know how you go up to Form 5, you have English, then you choose the rest best for or what? What are your thoughts on that?
Do you want to answer?
Well, I think nothing is impossible. Right now, we're doing the curriculum, we're thinking of TVET and giving pathways for students. Students can have, by the time they leave high school, students can have an academic qualification and a TVET qualification that happens in other countries of the world. So at the end, they can make a choice whether to go for the TVET when they leave school or to pursue their academic education. We can actually do the same for sports or something that's have pathways like that that students can actually choose from. Because we all know that children, they all have different abilities and talents, just like all animals in the world. Like the fish is different from the elephant, and then to stand them up next to a tree and say, "Fish, climb the tree," the fish will think that it's stupid for life because it can't climb a tree, but it was never made to climb a tree. So maybe, we have to really look into the different abilities, and if they are asking for that, I know in the consultations the students also ask for that. Maybe we should think of ways where there is also a pathway in this direction, which realistically is bringing a lot of rewards to students or people that have pursued it even without learning it at school. Thank you.
I'd also like to add that it's also one of our submissions for today, the submission of rugby to be taught, and also on section, clause 23, 3 part E, it includes sports, and it will be the prerogative of the National Curriculum and Assessment Authority to specify exactly what types of sports to include in the curriculum. But we will be talking about it today. Vinaka.
I raised this point on two issues. One, because it was made as a submission from Buddha. And the second one, I'm not sure if members, if you can remember, there was a bit of a whirlwind when the former Fiji Sevens captain, Isake Katarimbau, if you remember, I think so, Master Meti must remember, if you can remember, he was going around and make submissions. He even made a submission to the Parliament Committee on the sports, on rugby and education. Yeah, can you remember that, Honorable Usman? But no, even that's a former Fiji Sevens player. He's made a valid point, and now the submission came from Buddha Village because what rugby has contributed to this country is unachievable by any other sports. They've contributed to the economy, remittances, the livelihoods of the families, but it still seems to be just an extracurricular activity at schools. The point that has been coming across, if it's making a contribution to Fiji, why make it an extracurricular activity? Why don't we make it compulsory? Because probably it can heal some of the wounds of no children not going to school. Some just want to go for rugby. I'm probably not too sure. We've had Isaac Kotirimbo presented at this committee. It has been raised in Buddha. It's a very good point. Mr. Metu, you want to say something on that?
Yes, I do agree with what Ms. Nayang was saying. It can be a pathway within the existing education structure that we have. I mean, for us, we have either academic or vocational. So sports can be a pathway that we can explore through that submission, which to me, it's a very good idea to include that in our current education structure. I remember that a couple of schools were also offering this academy, sports academy. It'll be something similar. I know Lilin at one point in time was having this sports academy, and likewise I believe Marist as well. Yeah, they started off with that same concept, and it has worked for the school. I mean, it attracts the students, and I know some of these academies were working together with some other club overseas. So probably it's a good idea. I mean, from my own perspective. Naka.
Sorry, Chair, if I may, I'd just like to say that perhaps this conversation can also be a continued conversation when the regs are being drafted, if the bill is in fact enacted by Parliament, the specifics around sports and things like that.
Just 2 words. I think it might be best, rather than describe it as sports, say sports and professional sports. What it does, it just covers that umbrella. Yeah?
I think the good thing about what you have there is that all this can fit in there. So, and what you have to do in the bill is set the floor, below which you cannot go. But over and above that, you can build this other stuff. Eh? And that's what you said about language, or the floor. You can't go below it. But there's adequate scope under E and also under practical life skills to incorporate optional subjects or specific schools that might specialize in rugby. Bring it back to Lelin so you can win the Deans again.
Yes, that's a valid point as raised by Honorable Samate. I also would just also explain that clause 23.3 is the floor across all schools. Yeah, so that's why when developing it, we can only put things on that list if we believe there's capacity across all schools, or that the ministry can work towards building that capacity quickly by the time this bill rolls out across all schools. If we specify a particular sport that would create an obligation on schools that don't have a rugby focus to teach that specific sport, whereas some schools may have a focus on other sports like badminton or so in making a single sport requirement, it could inconvenience a great deal of schools. So which is why we refer to it at the minimum threshold level, which is sports. So sports have to be taught in all schools. It has to be something that students can learn about and do in all schools. But in the detail of which sport is to be taught, the curriculum can provide for it, but that should probably be optional for the schools based on their resource capacity. We now move to part 2, access to education. We note one submission, which was that entry into higher education, including the award of scholarships, that there must be requirements put in, that there be equity, fairness, transparency, and justice. Our position on that is that this law sets out, because it's a law, so it would be mandatory things across all institutions. And when the state is creating laws that deal with higher education institutions, there is a need to ensure that state intervention is light because of essentially the well-developed right of education institutions to determine their own standards of entry and qualification requirements. That's a fundamental part of the independence of higher education institutions. So if we were to prescribe how they are to recruit or the policies they must use for recruitment, it may be an excessive level of state intervention in the higher education institutions. So that's why it was not something that we developed originally, to allow the higher education institutions to continue to develop their own systems. And if their systems are in itself, or their systems are themselves unfair or discriminatory, then there are constitutional rights under the right to be free from discrimination. There are constitutional pathways, including pathways with the Human Rights and Anti-Discrimination Commission, where that could be addressed. But we wouldn't prescribe those things in the education bill. For comments on disability access, our position was that we note that there was a submission that there's a need to further define inclusivity and disabilities. Our position on the bill, which is why it has language around special and inclusive education, but it doesn't go too far into detail. And the reason is that we are relying on the current Rights of Persons with Disabilities Act 2018, sections 29 and 43, which set out a comprehensive list of the rights of persons with disabilities, and specifically in relation to education as well. So The Act actually sets out their rights in relation to education, the Rights of Persons with Disabilities Act, which is a specific law for that specific purpose. We also note that the definition is provided in that law as well, and it defines impairments as a condition which involves any loss or abnormality of the psychological, physiological, or anatomical structure or function of the body, and may include sensory impairments, such as those affecting sight or hearing, impairments with fluctuating or recurring effects, such as rheumatoid arthritis, chronic fatigue, a list of issues including depression, progressive impairment such as motor neuron disease, muscular dystrophy, forms of dementia and lupus, development impairments such as autistic spectrum disorders, dyslexia and dyspraxia, learning difficulties, or mental health conditions and illnesses such as depression, schizophrenia, eating disorders, bipolar, obsessive compulsive disorders, as well as personality disorders and some self-harming behavior. So it's a very comprehensive definition under that law and very comprehensive set of requirements under that law. So that's why those were not repeated in this law.
This was one of the issues that was brought up, especially in the rural areas. Eh? I mean, we had somebody talking about dyslexia. So when you say access for people, I think that was brought up in Buddha or somewhere there. So what does that mean, giving them access if they don't have access to the schools? Is there any contradiction there? The specialist schools. I think somebody talked about dyslexia or something. How does that gel? I don't get it.
So
What are we saying then that if you have access to education in those special things, does government have to provide? Like in this case, the student would have to go all the way to Subsau, which takes an hour or something just to get into the school. How does that all gel together?
Yep, and there is a requirement for the state to provide to ensure that there's access to education for all persons, including persons with disabilities. However, it's a progressive realization right. So a right that is progressively realized, meaning it creates an obligation for the state to move in that direction. Yes, but it must be progressively realized based on the. It has to be based on the resource. But the Constitution also does state that it's the burden of proof lies on the state to prove that they do not have the resources to make this happen. Another point we note is a submission which was in relation to corporal punishment, and the position taken by some members of the public that it is not unconstitutional, which means that the Constitution may allow for it. Our position on that is a nuanced position. We first state that it's not our opinion that it's unconstitutional. It is multiple rulings of the High Court of Fiji. So the High Court of Fiji has expressly declared by way of rulings that corporal punishment in schools is unconstitutional. We can direct the committee to two High Court rulings. That's Noshad Ali and the state, and also Bulava Karua and the Ministry of Economy. One is a criminal matter, and one is a civil matter. But the judges in both cases expressly declare that it's unconstitutional. However, the ministry's position on corporal punishment is that if the standing committee were to take the position that the clause were to be removed, this is well within the authority of the standing committee. Our position is that it amounts to a somewhat technical matter because the constitutional requirement and the Crimes Act would still apply. So if the intention of the public is to return corporal punishment, it would be processes beyond the review of this bill, and perhaps maybe considered by the Constitution Review Committee later. However, the technical issue of removing the clause, it's up to the committee, of course. We would just also like it to be known that from a legal perspective, it would not make much of a difference for the other laws. And to give effect to that public request, there would be other processes required.
We had a submission from the FTA in which the suggestion was made that if you take out the words corporal punishment by use some form of corrective discipline, that it could fall within the bounds of the rights of a child as defined in the Constitution. What are your thoughts on that?
Well, one of the cases I referred to earlier, Bulavakarua, the judge was quite clear in that case. The judge made statements that it would be a very difficult job for the state to be the arbiter of harm and determining whether one slap or two slaps, or so that judgment even considers that emotional harm would fall within the unconstitutionality framework. It's a very comprehensive judgment. I strongly encourage everyone to read it. But essentially, that would be the obstacle, right? If the committee were to call it something else, there's already existing High Court judgments which with very comprehensive language around how even slaps would be corporal punishment. So we, especially as legal practitioners, we can only advise based on existing law and existing rulings of the High Court. If we were to consider other options, it would be a bit like speculation. But our position is based on at least the Bulavakarua judgment in the High Court. Any form of abuse or which results in harm to a child would be unconstitutional. We also would point out that in that ruling, the judge also referred to the harm to other students, that if students witness corporal punishment, there could be emotional or mental harm to other students, the ones witnessing it. And so that's why it's a very difficult job to regulate the level of harm that can be permitted by a school. I think that the conversations around harm may be more well developed or have more perspectives in the home, but in relation to the school administered by state representatives for teachers or civil servants, it has the risk of exposing the state and the teacher to a lot of liability. So it would be something that would have to be managed very carefully.
Thank you, Chair. Done? Oh, thank you. Corporal punishment, as you say, is even if you take it out, it still be a principle of legality in the other laws. We need to make school a safe environment, not only for the students, but also for the teachers. And the Child Justice Act says the age of criminal responsibility is 14. We have students under the age of 14 who have assaulted teachers. Last year, a number of teachers were assaulted. And under this bill, if a student, the most you can do to the student is expel. Absolutely nothing else. That's it. And if the student is expelled from one school, under the right of education, he should not be denied entry into the second one or the other school. So how do we, are you listening to me? All right. So how do you make the school a safer environment for the students and also the teachers? Because we are We are not even talking about teachers here. And at home, we have 3 kids, and we get our hands full. They're teaching 30 kids, 40 kids in one classroom. And out of that, there are some kids, students in the classroom, who get physically violent and assault teachers. Where do we draw the line? How do we take that corrective measure? The most we can do is expel that student from that school. He or she may get entry into another school. We are making our schools very, very safe for us to the children, but at the same time, it's becoming an unsafe environment for the teachers. We need to strike a balance. I'm not here advocating that there should be corporal punishment for all the students or whatever it is, but how do we strike a balance? How do we keep our teachers safe? Because any student under the age of 14 will get away scotch-free if he or she assaults a teacher. There is no stop to its education ability. The process still continues. He gets expelled or she gets expelled, goes to the next school and say, I want an entry in there. The principal or the head of school cannot deny enrollment for that particular student. The student continues. Life goes back as normal. But this pain, the psychological effect, and the trauma the teacher experiences, how do we counter that? We need to do something. There has to be a line drawn somewhere. And it's important. Because teaching is a profession that needs to be respected. And nowadays, I've seen that respect is diminishing in some places. And I've had conversation with teachers who come into tears explaining their experience in schools. So this bill is good. But what's the safety mechanism or protection or the baseline protection safety mechanism for our teachers? Very, very important for that to be considered too.
Thank you, Honorable Member. How we've addressed teacher safety is we've increased the fine and the penalty for harming or abusing or harassing a teacher. I take your point, though, that some criminal offenses will not apply to children because the age of criminal responsibility is from 14, or at least will be from 14 when the act commences, when the Child Justice Act commences. So it is raising that criminal age of responsibility. So what do you do about harm from children under 14 years, right? Because then the penalty, raising the penalty doesn't really affect those under 14. It's a valid point. We developed this bill based on existing constitutional limitations. So we could not realistically employ corporal punishment as a solution to that issue. So we had to look at other alternatives. So the alternatives here are just ensuring that that part of the curriculum, morality and discipline, is taught. Civic responsibility, morality, and discipline is taught so that it's instilled to address behavior. If a child is violent, then there may be underlying mental, medical, or health issues. So ensuring that counseling is an option provided to actually address the root cause of that violence, and instead of simply beating the child down. So we looked at these other options to address student behavior, but that is possibly as far as we can go within current constitutional limits.
Thank you. Like for compulsory education, if the child does not attend or go to school, the parents are held responsible for it, criminally held responsible because there is a jail term attached to it. Now, if the child's behavior in the school goes beyond what is expected of a child, and if the child assaults or attacks or performs any behavior that is demoralizing, the parent should be criminally held. There should be somewhere someone should take responsibility of it. Because we need to create an environment safe for the teachers. So if you can't do anything to the child, the parents should be held criminally responsible and they should be taken to task. Because the morality and everything begins at home. If they are failing to teach moral or good behavior to the children, then if under this law the child cannot be harmed, there is no corporal punishment. I'm not saying whack the teachers or cane the teachers, but they should be held criminally responsible for it, just like compulsory education. I think we need to be fair somewhere.
I think that's an interesting point, and could we get back to you on that point later when we will go and look into the possibility or how we can. We will consider that option and let you know. I do know that there's some framework for transitioning or like transferring or extending criminal responsibility, but it's a heavily regulated type of legal framework because there are constitutional protections for only really getting criminal liability if you are responsible. So it's about connecting that responsibility. So it is perhaps possible. I would just want to do a bit more research on it before I get back to you.
Chair? Just a quick question. I'm not sure when the last Universal Periodic Review was done, but was that something that you guys had a look at before on this particular issue with respect to corporal punishment? And is there something that may come into play and look at our situation with respect to whether we're compliant with our international commitments, etc.? So I'm not sure when the last UPR. You would know more about it, I think, David.
I'm not sure when the last one was. I've been away from the office that is responsible for that for a fair bit, but I do know that in our there has been pressure from the international community under and with frameworks under the conventions for Fiji to remove corporal punishment. So we would currently be non-compliant. But the fact is, only one aspect was remaining, and that was the statutory defense, because the Constitution prohibited corporal punishment. It's just not all the laws had been fine-tuned to reflect that position. But in 2024, the last remaining provision in law that even remotely allowed for it, which created a statutory defense, was removed. So we are currently compliant because it's unconstitutional and there's no statutory defense available under our laws. And it's a crime under the Crimes Act. So that's why we are, in the current state, I think Fiji is compliant, but prior to that, there was strong pressure to remove the remaining statutory defense.
Okay, we'll come back to that. You can move on now, David. I'm mindful of that time. But very good point.
What do you mean by statutory defense?
So that would be section 58 of the Juveniles Act. It stated that it is a defense to the offense of assault under the Juveniles Act if the force used was reasonable and in relation to by a teacher or a parent for reasonable punishment, I believe. Yeah, reasonable punishment. I think that was the language. So that was under Section 58 of the Juveniles Act. But that provision has been repealed. Will fully, once the Child Care and Protection Act 2024 commences. So that statutory defense, though, applies to that offense under Section 58. So Section 58 sets out the offense of injury, assaulting, abusing, I believe, or insulting as well. It's a range of offenses in relation to a child. So harm to a child, and it includes assault. And so it created a defense to that charge. But Section 58 also specifically states that for serious cases, it would go under the Crimes Act, not the Juveniles Act. And there is no statutory defense under the Crimes Act. And then Section 58 will be repealed.
Just, sorry, along those lines, can we insert a statutory defense for this? Just to work within the boundaries of school?
So a statutory defense, it would depend on whether the courts find that statutory defense to still be constitutional. The reason why that defense existed was because it's from, I believe, the 1950s. Yeah, it's a very old defense. There is a position that under Section 173 of the Constitution, when the constitutional rights or the Constitution commenced, all laws in existence at that time are modified to be in line with the Constitution. So originally, I would have read that modification as just a technical modification, but there have been rulings of the court that extend that modification to more substantive modifications, that you have to align all the laws to the Constitution, which is in line with the position that the Constitution is the supreme law. So even if we were to reintroduce a statutory defense, there's a strong argument that it would be contrary to the Constitution. But I would say that then we are heading into opinion territory because there's no direct High Court ruling on this specific question.
Yes. Then we'll just have to leave it to the court to decide.
Yes.
So there's a possibility of putting it in there.
There is a possibility
Let
of
the court
statutory
decide it.
defense. But it would be a significant and very quick change because we have a law from 2024 removing it and then a 2026 returning it. So then there would have to be, at some point, I'm sure if it ends up before the courts, decisions would need to be made on whether it's in line with our international commitments and the Constitution. I would think that a strict reading of the Constitution would be that it's unconstitutional, but that's for the courts to decide.
Okay. Yes, Ms. Kula.
From the Ministry of Education side, our stand will always be on the best interest of the child, because we look at children as the most vulnerable of the society. At the same time, the Ministry of Education is looking for ways to look into teacher protection and safeguards with regards to teachers, which will have to align under this current education bill once it's passed. Through the public consultations, we've noticed there's a lot of gaps in our policies with regards to disciplinary approaches. And that is something that we are going to look into and we will review. Not only safeguards, teacher protection, behavioral management, as well as the positive disciplinary approaches that we can implement from the ministry side. So from our side, we are reviewing teacher protection as well as safeguards. But our stand will always be on the best interest of the child. Vinaka.
Naka. Thank you. Can continue, David. Huh? Okay, last.
There's nothing. Is there anything lost if you remove all mention of corporate punishment?
Our position would be substantively no, because the Constitution and the Crimes Act would still apply. Yeah. And if there were no High Court rulings on that, it would be trickier for us to make that answer. But because there are High Court rulings expressly saying that the Constitution and the Crimes Act prohibit corporal punishment, that's why our position would be it would still be unconstitutional. It would be fine because those frameworks would provide for it. We also would point out that we understood that there was a submission that directed the committee to look to Section 41 of the Constitution and the right of a parent to choose. And we would just point out that Section 41 is entirely about children's rights. It does not make any reference to parental rights. In fact, Section 41 only states that parents have a responsibility to ensure that, even if it's one parent, that that the right to education is provided or is able to be accessed. So that would be Section 41, subsection 1, paragraph C, which is the right of every child to family care, protection, and guidance, which includes the equal responsibility of the child's parents to provide for the child, whether or not the parents are or ever have been married to each other, and whether or not the parents are living together, have lived together, or are separated. So that's the reference to parents in Section 41. It's just that parents have a responsibility to provide for the child. And it's also worth noting that that same section, when specifying the rights of the child, specifically says that the child has the right to be protected from abuse, neglect, harmful cultural practices, and any form of violence. Violence, inhumane treatment, and punishment. It also specifically says that the best interests of the child are the primary consideration for every matter. So we only raise this just to point out that these references to parental rights, that's not there under Section 41. So the next one is compulsory education. It's I believe the contentious issue here was the criminal criminal element, right? Enforcement through criminal law. So for this point, we just wanted to first say that we have heard and we acknowledge maybe the validity in reducing the imprisonment term from 12 months to 2 months. That's something that may be arguable, and so we could concede on. But we just want to make clear some things that perhaps were not considered by members of the public, and that's the framework under the bill doesn't jump directly to penalties. It begins by requiring the PS to make inquiries into the matter, and only if the PS is of the view that the reasons given are unsatisfactory does the PS proceed to issue a direction. So that's first stage, is PS applying a level of discretion based on the circumstances. And only if in the PS's judgment there's no sufficient reason for why the child is not sending the parent is not sending the child to school, then the PS can move to make a direction. So a level of reasonableness would be expected by the PS in using this power. Then if it's still not complied with, then the PS seeks a court order. So here we have another level of discretion and reasonableness that we would expect from the court when the court decides on what order to make. So the court can send them to counseling, send the parents to counseling rather than seeking direct penalties. So this is a framework where we expect fairness and reasonableness, which the courts and executive authorities, they have that discretion in many areas across the board. So trusting on existing systems to make fair and merciful decisions. Then only if the magistrate sees fit to make an order requiring them to send their kid to school, then if they still don't listen to the magistrate, did not comply with that order, then we can move towards the charge and the penalty phase, which is again its own phase, regulated by criminal processes, by court processes as to fairness, defenses, individual circumstances taken into account long before we get to the sentencing phase. And then within the sentencing phase, there's also an expectation of reasonableness based on mitigating circumstances. But all of these things, especially within the court process, is governed by existing laws. For example, the Sentencing and Penalties Act. Under Section 4 of that Act, it expressly states that the only purposes for which sentencing may be imposed by a court are, and paragraph A is to punish offenders to an extent and in a manner which is just in all circumstances. So sentencing is something that's limited to sentences which are just. So that adds that element, that requirement that be considered by the court before making a decision. And then the court also has other powers. So under Part 9 of the Sentencing and Penalties Act, the court also has the power has a variety of options instead of imprisonment or a penalty, including a discharge with or without recording a conviction. The purpose of these powers are also expressly provided in that part, and it specifically states under Part 9 in the first section of Part 9, Paragraph B, to take account of the trivial, technical, or minor nature of an offense committed, to allow for circumstances in which it is inappropriate to inflict any punishment other than nominal punishment, and to allow for the existence of other extenuating or exceptional circumstances that justify a court showing mercy to an offender. So how courts determine the appropriate penalty, it's governed by all these existing laws that require a level of justness, a level of mercy, and a level of fairness. So it's not a jump directly to if you do this, you will go to jail. The court has so many options, including under Section 10 of the Community-Based Corrections Act 2018, the court is well within its powers to make a community-based corrections order instead of a sentence of imprisonment. So these options are all the existing law options that we did not replicate in this law, because they are already provided for in law, and they are what we know based on experience and based on court process will be used by the court system when deciding what penalty to administer. And then before we even get into all of that, where there are unique circumstances, the person may also get an exemption directly from either the PS or the minister, depending on the circumstances. So
Why is there no explicit statement saying that you have to jump through all those hoops before you get to the extreme sentencing?
no, it is there.
It is there?
Yeah, the clause does provide a staggered framework. Only if this is not done, then this is this. So it's step by step. And we did not replicate all these other language in the Sentencing and Penalties Act, Community-Based Corrections Act, because we were aware that they exist to ensure that the system is regulated fairly.
Can I just quickly, sorry. If a child, correct me if I'm wrong, Tim, if a child is can be criminally responsible from the age of 14, if I'm correct, then why is it, and it's actually quite unclear that why are we still making parents liable or criminally responsible right up to when they're 16? Is that something that you had to look at?
So yeah, the responsibility we did put on the parents. Yep, the offense is for the parents. So that is a fair point. That for a specific age, like 15, so the compulsory school age under the current Fijian system is 15. So there is 1 year that I believe it's possible to shift that responsibility to the child. But in these circumstances, the child is still within the control of the parent, or most often under the care of a parent or guardian. So the position we took was that if the child is still under the care, responsibility, and of a parent or guardian, then it is the parent or guardian who should be responsible for whether or not they are being sent to school. And we heard statements. Yes. Oh, that's right. It's also because the obligation looks at the parent more, because the state provides these grants to the parents, allowances, etc., in order for the parents to bring their kids to school. So the state's relationship is with the parent in relation to all the benefits the parent is given for their child to be brought to school. So the lens of responsibility we peered particularly through was the parents.
Thank you. Just leading on from his question, because we need to have some sort of consistency in ages. Where the Child Justice Act says criminal responsibility 15, and here 14, and then in the education bill, we are shifting after the age of 14, we're shifting it to the parents. There is a bit of a gray area. And the other thing that you just mentioned is that there are other what you call laws that will be considered before coming to a judgment. Probably there should be a reference to those laws in the bill. And the third is that after jumping through all the hurdle, the court decides, yes, the parent needs to be sent to jail for 2 months or a year, depending on what the final bill says. Now, you just mentioned that you're looking at the best interest of the child. And the bill is not clear, is the parent or parents? If it's the parents, then both of them go to jail, the mother and father. Now, best interest of the child, what if that's not the only child of that parent? There are other childs around, or children around. Not the child, there are other children around. So, what is the best interest of the children who are left at home for the number of days, the parents, because it does not signify one parent, it says parents. So, what happens to the children at home who are left behind, and why should both the parents end up in jail? So, the law says, or this rule, the education bill says the parents should be sent to jail if everything fails, or whatever you have done. So there is no clarity in there. And when you say best interest of the child, if the child is under the age of 14 or 15, and the parents are sent to jail, who looks after the children? The state? And for how long? And what will be the state's obligation?
So that's a fair point, but just to perhaps provide more clarity on that, we do not believe that those types of situations are likely to result in such a severe outcome by the courts because of those very provisions I referred to in relation to justness, extenuating circumstances that require the court to be merciful, the option of instead of imprisonment term, community-based corrections orders, so they work within their own community. These are so many options that we believe the court is well able to administer and consider in order to ensure that there's no unfair, unjust, and harmful outcome. It's also that the laws provide that the best interests of the child are the primary consideration. So if the child were to be left without parents, it would not be in their best interests overall. And the reason why we have faith in the court system to administer this framework is, one, fine-tuning it may be a bit too prescriptive when the court has demonstrated the capacity and the ability to administer these systems fairly. For example, what is the term here? It's like alimony. It's the amount that spouses have to pay. The courts in situations where imprisoning a spouse would result in them not paying anything has considered merciful other options. The court does this on a daily basis, consider cases within the specific circumstances of that case and make their decisions fairly and mercifully. And so the court is the authority with the most experience in making these types of calls and decisions, which is why we were of the view that they are the best authority to ensure that the system does not result in unfair and severe outcomes.
My argument is, then why make it a criminal offense? Just restrict it to fines. The parent should be allowed to pay the fine. If they don't pay the fine, then you have other procedures under the court that you can undertake to recover that. So if you are looking at the best interest of the child, sending the parent to jail is not the best interest of the child, and it should not be there. You can say, if you are, caught not sending a child to school, and after exhausting everything, that you are responsible for not sending your child to school, there should be a fine. Not criminalizing it. And why I'm saying that, we are now looking at another bill, which is Criminal Records Bill. We are trying to give people a second chance, and here we are trying to send a parent to jail. for not sending a child to school and then have a criminal record against him. We need to be consistent with our approach to our society.
Sorry, before, just to note that that framework for where fines are not paid, it results in imprisonment. So if a fine is not paid, if the court orders the payment of a fine and it's not paid, under the Sentencing and Penalties Act, the court may order imprisonment.
I totally understand that.
Yeah.
You can.
Yep. So
the
I know
ministry can take a DDS and get to recover. If they still don't pay, there is penalty or sentencing, which is okay. But in the first instance, under the education bill, I don't think sending a parent or having a provision where you can send a parent to jail for not sending a student or child to school, I think it's we are not being consistent and we are not being realistic.
Can I add? I think the Child Care Welfare and Protections Act, which was passed by this committee, passed by Parliament in December 2024. It also states there that if a parent is neglectful and does not comply with their duty of care, they can be sentenced to a term not exceeding 2 months, as well as a fine of $2,000. So in terms of consistency, there is penalties and criminalization already that was passed by this committee.
I'm just looking at the offense here, David. It's negligence, eh? Yes, negligence can be civil and criminal in nature too. But I have a different question. But since we are on the question of compulsory education, probably this will be better answered by the ministry. Is in your position to maintain compulsory education till the age of 15? I raise this point because in the submissions that we heard, some objected to the idea. It's basically defeating the whole idea of education, to limiting it to 15. And they had a very good point. I'm thinking along the lines, when you, from class 1, which is year 9, year 1, all the way up to year 10, which is probably the 15 year age limitation for compulsory education, you have not set an external exam provided by the state. Okay, that's one point. Secondly, in terms of employment, currently, the minimum that employers give is you have to have a Form 6 pass. You know, nearly everywhere, even if you want to be recruited by the police, Form 6 pass, Form 6 pass, Form 6 pass. I want to hear what's the stance of the ministry on this. We are pushing for compulsory education, and then there's a limitation that we have under the education regulation for 15-year-olds so that it can align itself to the Employment Act. That's understandable. But then if you go beyond that, everything is Form 6 pass. The minimum to work anywhere is like Form 6 pass, even in private sector, for the government. No, I don't see the logic behind it, because the whole idea for education is for the child to get a good education. And then everywhere, try and get an employment, minimum is Form 6 pass. But then we are restricting this so that it can align itself to the Employment Act, which is understandable. I'm fine with that. Consistencies in the laws. But the logic of compulsory education that we are pushing for is missing here. Okay? Is missing here. I'm just thinking, what is the stance of the ministry moving forward? Will you still maintain the regulation at 15 years old for compulsory education, or are you opening it up to, because the logic behind this is missing, in my opinion. I just want to hear what is the ministry's stance on this, because, like I said, from class 1 to Form 4, you haven't set an external exam currently, and there's no position that ministry is showing that they intend to reintroduce class 6 exam, which is Fiji Intermediate, class 8, Fiji 8th year examination, or Form 4. There's nothing being promised so far. Okay? And then how do you gauge our students? We are pushing for compulsory education. The key word here is compulsory education. The logic is defeating this. Okay, I understand the 15-year-old so that it can align itself to the Employment Act, but Nearly every employer here, the minimum is Form 6 pass. Okay, I just want to see what is the ministry stance way forward, because we want this to be effective 10 years down the line. Okay, with no amendments. Probably if there are any amendments, let's go 10 years. Any comments to that, the ministry?
Ideally, it would be good for it to increase. Currently, it is up to the age of 15, from 6 years to 15 years of age in the current Education Act, and it is found not in the Act but in the regulations. There's factors that from the Ministry of Education that we do have to consider, and one of this would be the financial implications as well, because under the employment regulations, a child can start work at the age of 16. Let's say there's a scenario, a child is 17 years of age, they're enrolled into school, a class audit is done, the school receives a FIG, the free education grant, and then halfway through term 1, they decide they want to go to work. They want to start work, and they apply for exemption, and they work. So what happens to that money? So there's other, and then it's also the monitoring in terms of the Ministry of Education, because they'll have to apply for exception, and then we'll have to do verifications and other things. So it's not only financial implications, but it's also the resources that the ministry has to monitor the compulsory education from 6 years of age up until the ideally 17, 18, 19, or 20 years of age. So the fact that it is still at 15 is not only because of the Employment Regulations Act, but also because of the capabilities of the ministry within its budget to actually monitor and have verification factors on this. Additionally, we are requesting that it stays in the regulations and not in the legislation, specifically because we do not want to create a mindset that once people see that compulsory education is only up until 15 in the actual legislation, then that will give them the leeway to say that my child does not have to go to school at a certain age. So it is something that we are still discussing, and it's something that we'll have to take into consideration, not only in terms of our ideals, but also in terms of the financial implications, and that we will have to work towards. So our request is that we are still in discussion in terms of this, and we requested if it could stay in our regulations and be the prerogative of the ministry with regards to our resources to implement Vinaka.
Thank you. Very good reasoning behind that. Oh, yes, you have something, Honorable Kwar?
Yes, Chair.
Along those lines?
Yes.
Okay.
Same thing. I'm not saying I disagree, but I just would be good if you just heard this, because for any democracy, for any nation, the cornerstone is having an educated population. If you go to many places around the world, I think the emphasis is on that. So you actually end up creating a better environment, a country that can rely on its populace with respect to having been educated up to a particular level. I don't see any reason why we can't say that education is compulsory up to the end of high school. And Chair has rightfully pointed out that anywhere you go in terms of employment, you're looking at how far have you gone, right? If we are putting in compulsory education, making parents criminally responsible, right? Why is it that we can't say to ourselves that we must put something in there so that our society has a bare minimum education of up to the end of high school? I mean, we encourage the mature students at the end of the day who have missed out, all of those things. Why is that so? It's because the compulsion is not there. If the compulsion is there, and I think this is a case where the state will find the resources, because only the state will benefit from a person having an education, earning more, because at the end of the day, this particular portion of society is what runs the country, the educated particular person, or not even those with little education, but it only helps us, it benefits us. So we have to look from that perspective and work backwards. If we want to become a modern nation state, these are the things that you have to look at. I totally agree with what Chair is saying, that what's the reasoning behind it? The policy should be, let's educate. If you look at all the examples around the world, it's education that has been prominent and paramount with respect to making sure that we've got a good society that is able to learn, able to comprehend, able to speak. We are known around the world as one of the best English-speaking nations in the world. Why? Because we speak English with such clarity. If you look at all the different sectors that are involved, the opportunity is great for us to take advantage of. Our people who are educated in terms of nurses, in terms of doctors, in terms of teachers, etc., are in high demand. Why? Because they educated themselves. So my point is that I believe that we should look at somehow or the other extending it to high school. Compulsion. Even bearing in mind also, we are telling parents, if you don't send your kids to school, you can be criminally responsible. But we are doing that only up to a nurturing stage, not to a stage where a child is like fully fit to do whatever he or she chooses at the end of the day and makes that choice about his career.
I absolutely agree with you, sir. That is why we're requesting if it stays within the regulations, so the Ministry of Education can probably review its resources in terms of implementation if it is increased up until 19 or 20 years of age. Vinaka.
I think I'm not trying to rebut anybody, but if we are thinking of the best interest of the child, we must extend that now. It's not our problem who's going to fund it, but this act will go for 10 years. Along the line, we know, because it's in the best interest of the child to get the best education, and that is what we want for all our children. So maybe we should consider what is in the best interest of the child. And though we do not have resources right now, but that's the worry of the gentleman on the other side of the...
Of the government, yeah.
Yes.
Sorry.
What is in the best interest of a child who is not gifted academically?
Well, like they
Let
said,
me finish. And then can become a Ndaro farmer and a Yangwana farmer at the age of 16 and earn $20,000 in 1 year after 3 years. What would then be in his best interest?
well, thank you. We can say that it's in the best interest of the child to be educated to this age, but if they choose a better option, like get a job, they can go and get a job, but otherwise, then we're not providing for the rest. There's a very few people in that category, Mr. Usam.
It's brought up in villages. I think Nayaroyaro. In Dongotuki, they said the kids at 16, they start planting. By the time they're 18, 19, they've got homes. And some of these kids are not academically. So I think the idea is good, best interest of the child. But what exactly does that mean? It might not be the same for everybody. That's the point. Eh? It's a difficult question to...
Yeah, but what I'm saying is that we have to have that, like a lot of people would want children to go to school, except you can make an exception, except when they have an option, like when they get a job or when they do farming. So maybe you can design it such a way that all children go to school, compulsory education up to this, exceptions are this, and then needs to be approved.
David, you have something to say?
The good thing that it's in the regs, eh?
Yes.
It's not in the mother legislation.
Yeah.
Gives you the flexibility.
Yeah. Just 2 points. The first one is that, I mean, this is a noble ideal, and the ministry, I'm certain, like, truly wants education to be compulsory. It's the realities and the practicalities that we're grappling with. So first point is we cannot set an age that is contrary to the age in the employment framework, because then the two laws will clash and people will be unaware, or no one will know which one would apply. Because if one law is saying no, you can actually go to work and be employed, and another law is saying no, you have to be in the classroom, these two laws would clash. So we are aware that the employment age limit is being amended under the Employment Relations Bill to take it up to 16. But even putting it at 16 actually just fixes an earlier clash error, because now compulsory is up to 15, and then from 16 you can work. So that just fixes that clash. So we would need to comply with that, or if a change happens here, a change has to happen there as well. When the second point I wanted to raise is that when deciding whether there's a need to change the age and increase it, we need more data. We need more data on, because the available data on employment of children, it only shows us child labor, which is a very specific definition. But what it does show is that child labor is by 42% of children who are engaged in child labor. 42% are from the poorest quartiles. So that means that the families that are using employment rather than schooling are the poorest families. So we would need to know how this would impact so many families across Fiji. So without that data, we were of the view that you can't put a specific high age in the Act, that through the regulations, which is the time-honored process, because even under the current Act, it's through the regulations. Through the regulations, we will prescribe an age after we have gotten the data on how many families could be impacted and what the impact would be generally. Because unfortunately, some of these very poor families need this resource, need some of their kids to start working. So although we really want to have an age, that age group as high as possible, so we have a very educated population, the fact is we have to ensure that our policy and the law that we make has as little harm as possible when it rolls out.
Thank you, Chair. Just, yes. Best interest of the child. That's the biggest question. Now, we have heard from ministry and other submissions that today's child is maturing much faster than a child who 20 years ago. Systems are much better, the development is much better, they understand things much quicker. Now, I don't want you to answer me straight away, but probably something to ponder upon. Who decides what's the best interest of the child? A child who is matured enough to think about himself compared to a child which was 20 years ago and he's at 14 or 15? The parent who's nurturing that child and is providing for everything except the school fees and the bus fare and the back to school? Or government who only provides the bus fare, the school fees, and the back to school? Now, I don't need an answer from you, but I want you to ponder upon this. A child who's maturing much faster than what a child would have done 20 years ago or 40 years ago, or probably 50 years ago. The state who provided the $200 back to school, the bus fare and the school fees, or the parent who have nurtured their child throughout, day in, day out, through thick and thin. It's a very serious question and needs to be thought holistically, not only that we only look at the best interest of the child. We need to holistically look at the best interest of the child.
Just a question to the ministry. When did you introduce the idea of limiting the compulsory education to 15 years old? Like, when was it introduced? What year?
1997, around that time. So it was a progressive framework that expanded every 2 years, every year to a new area of Fiji. So it started with one area, then it moved and moved from 1997. That's why it stopped in 99. And then, to our understanding, because of the coup in 2000, it didn't continue. So actually, under the current framework for compulsory education, it does the orders. They don't cover the central district.
Also
it's
Lotoka
because it was-
Yasawa.
Yeah, and the Yasawas. Yeah.
Just
So
for
these
the-
districts currently are not covered, but in the new framework, all of Fiji will be covered.
For the information of the members, who were the initial districts that started off the compulsory education? Can you just inform the members, please?
Raki Raki.
Yeah, Rakiraki.
Raki Raki, Vakondrove, Eastern Division, Maduata Mbua, Nosoi, Nandrangan Navosa, and Ba Tavua.
Do you have a reasoning? Was there a reason why they started with this district? No?
Yes, based on resource capacity, and so when it was first introduced in the 90s, they had to see whether it was possible. So they started with certain districts and they moved it progressively. And the last was going to be the central district and Yasawas. Yeah, Lotoka and Yasawa. But they didn't get to that.
Okay. Yes,
So-
sorry,
so-
I'll just take from Ms. Voraj first, then Ms. Veskula. Sorry. Ms. Voraj, please.
I would think that it was also to encourage these very rural areas to send their children to school, which is why I believe, like, places like Suva were sort of left out.
Yes, Ms. Veskula, you have something to say?
So that basically means that our current Education Act, compulsory education, does not apply to Suva district as well as Lotoka Yasawa district. Our current act.
The current.
No. Sorry, our current existing. Yes, the new one will cover all. And I think there's also those regulations also established these different districts, and we follow those districts as well with our education system.
Okay.
Naka.
Honorable.
This is a long time coming. You guys mentioned that right at the outset. Many, many years have gone past. This is also inspirational and aspirational. Right? So, what is the harm in putting it in there? Because you've also made provision in here where it says if the state can't find the resources from a resource perspective, it just has to explain itself as to why it can't find the resources to take it to that particular level. But putting it in the law now will be of no harm to ensure that it's done and then to get it right. And also, we have many facilitative clauses in here which say that, okay, if we say, for example, ILO 138 says age 14, 15, that's also quite ancient. Right? We have to look at it from our development perspective to say that we need our population to be educated. And the percentage of people that you're saying that are going to probably leave school at 15 to go and work, if you look at it, I believe that it's still quite a small percentage. Most people need to, most parents now push their children to go get educated at least to that particular level. So, what would be the grave objection if, for example, we put that in? Is it going to be harmful? Does it cause any harm to the state? No, it doesn't. Because if you put that facilitative clause, that if the state is unable to, then it just provides a reason that we can't do it up till that particular stage, like you've done with many other things. So I think to be facilitative, to be aspirational, to be inspirational to our kids, we probably need to put that in. That's my opinion.
Sure. So, unfortunately, it's not entirely about what the state can provide. It's also about what the families require. So if we put the strict age in the Primary Act, then it fixes it. And for some families, if you take away a source of income that they need, that wouldn't be state's assistance for education, that would be state's welfare assistance for the family to be fed, to pay their bills. So it's a much higher level of assistance if a family needs that source of income, but the state requires them to not have it, for them to just send their kids to school. Ideally, we want every year to be compulsory, but it's just the harm element. We don't want to result in a situation where we unintentionally cause harm to the poorest percentile of the population and members who may genuinely need these situations. It's also not just the maximum age, it's the minimum age, right? So the minimum age currently is 6, and within state resources, they can't currently the ECE centers all over Fiji to cater all over Fiji. There are practical difficulties around lowering it to 5. So both the minimum and maximum age have their own unique challenges. The minimum age because we need to ensure that those centers become available all across the country before we make it mandatory for parents to send their kids to these centers. And then the maximum age, we need to ensure that the harm element is very carefully considered with data. If we have the data on the number of families who will be impacted, what assistance or what form of welfare can be provided to ensure that these families are taken care of. If it's a very large number, does the state have the resources to do that? That's why, and also the final technical fact that we have to align with the employment framework because that law is also a law. So, I mean, that's also a law that applies here. So we need to be consistent with it. We've put it in the regulations to allow for it to go up as the employment age goes up. And for all of the decisions around that to be data-based decisions that closely consider the harm element.
Just a final comment on compulsory education. From the Ministry of Education side, I would like to make a submission for amendment for the penalties to be reduced from 1 year to 2 months to be consistent with the Child Care Welfare and Protections Act. Vinaka.
Thank you. Thank you. Just before I give it back to David for us to move on, I'll just ask a question to you, honorable members. Were you aware that this came in 1997? Right, that's my point. During our consultations, most people did not know that the age of compulsory education was 15. Now, this is the concern that I'll raise now, is for the ministry and the drafters and everyone. I will put it on record. When we will table this report, I will have to mention that. And we are opening a floodgate. Remember that. Remember that. Children will exercise that right. They will exercise that right. Maybe not in the rural areas, but for Suva, I tell you honestly now, they will do that. That's fact. They will exercise that. Okay? Now that is the concern that you and us, we have to deal with that. Most of the people never knew about this compulsory education being limited to 15 years old. When Ms. Vesukula told me, that was the first time in my life I heard it. And now we asked, when was it introduced? Way back then. Even these members, they've lived so long, they never known about that. When we went to the communities, they never knew. Now when we went for consultation, we've been telling them, when this bill will be tabled, it will be announced. We will open a floodgate. But we'll leave it there, we'll try and solve it. Okay? I'll give it to David to move on. Please, we have other matters. We have other matters. David, next topic. I'm mindful because we've been sitting for 2 hours.
Yes.
Unload. Naka, next.
Thank you, Chair. So I think I'll move to yeah. So we are open to another possible concession, which is in clause 58(1)(c).
58(1)(c).
We note that a member of the public made a submission about 58(1) being too restrictive. and we've taken it into consideration, and we believe that the removal of paragraph C would make that system more fair or fairer. 58(1)(c) requires before a homeschool is approved, it can only be approved if there's no other school in the area providing that. And under consideration, we agree that that would be too restrictive for homeschools. So
So it is your submission that that be removed.
yes, 58(1)(c). 58.
58(1)(c). 1C, page 29. Flexible.
Yes, yes, yes.
There's room to breathe. Naka?
I'm just going to say for all the other elements to be included in the curriculum, as Honorable Samate said, we are of the view that these are the requirements for the bare minimum. Any additional curriculum matters, for example, sex education. We noted a submission on sex education. We believe that's for the authority to determine. So the other potentially contentious issue was the levies. And so it's the position of the ministry that levies should be voluntary. But having considered the difference between a levy and a fundraiser or a fundraising activity, if it were purely and completely voluntary, then it could be covered by a fundraising activity. So after discussions, the ministry is leaning more towards an amendment to the levy clause, instead to state to expand the permanent secretary's ability to control the levy system so that there's a bit more fairness. So currently, the permanent secretary has control over the amount to ensure that the amount is fair, but to grant that an additional authority to set conditions, and those conditions could include whether or not it's voluntary, so mandatory, and the circumstances in which it could be mandatory or voluntary. So how that would work is if a school genuinely needs additional funds through levies, it would give the permanent secretary the ability to, within the circumstances, review the matter and ensure that perhaps it can only be mandatory for a certain income threshold, so that the lowest income threshold of that school are not affected and don't have to pay a levy. And so a tiered system based on the particular circumstances. So to expand that to include conditions to ensure that the system is fair and doesn't disadvantage certain parents and students.
So just a question to the ministry of this. Do you have the current format for that in the ministry? I'm just talking about the ratio or the amount, you know? Yes. Do you have in your policy? No? For the ministry?
Currently, we don't have any format on levies because there's never been levies that was administered for the past, I think, 16 years.
Okay.
But it is something that we will look at in regulations because according to our current, according to the education bill, it will be prescribed by the Honourable Minister through regulations.
Okay.
Yes.
Because David is proposing that there be a certain number of amount, eh?
So it would be that through regulations,
Yeah.
and through considering the case-by-case circumstances,
Okay.
conditions and control can be, and so a policy would be developed, and this would go in the regulations.
Okay.
What you're saying is in the bill, in the law itself, it just says levy and fundraising is allowed. The conditions will be specified in the regulations.
Yep.
And you have not come up with a draft of what those
So
conditions should be.
we've set out in the bill what levies can be for, but not the conditions on application, because that can be very technical and based on the individual circumstances of a school.
The current condition is upon approval by the Permanent Secretary of Education, and we've stated that in the education bill. But in terms of the detailed conditions, that will be in our regulations.
can you just probably later on just show us a fair how you intend to do it, so that we have a brief idea on how you might want to do it? Because, like I said, your regulation for 15-year-old, no one knew. No? So, we want to have a fair idea of what we are signing off on. No? Okay?
So in our defense, it was in the, it's in the laws from 1997.
Okay.
Yes. And everybody has access to those laws.
Oh, it was in the bill, in the act?
No, it's in the Act, it's in the regulations
Okay.
since 1997.
Okay, yeah.
Vinaka.
So if you can just show us how you, in your regulations. Thank you,
Chair,
David.
just a clarity. Enrollment fees, do they form part of levy or is a different category altogether?
And so currently the only levies that are allowed to be imposed are the PTA levy. No other levies. It's currently, it's the PTA levies.
Okay,
Yes.
Thank you.
great, thank you.
Just be mindful, we have
Upon the approval of the permanent secretary, a written approval, and I think a circular went out from the Ministry of Education last year in November, which specifically stated upon approval of the permanent secretary of education, Vinaka.
I'm mindful that we have another submitter waiting outside. So I'll give you until 1:30. And we can schedule you again. We can schedule you again. They are to appear before this committee at 2. Sorry. So probably last 2 points that you want to put out to the committee?
Perhaps the Education Tribunal, we had a recommendation that there be a special education tribunal. Our position on that, for teachers, our position on that is because they are civil servants, they are covered constitutionally under this Public Service Disciplinary Tribunal. And the Constitution sets that mandate for the PSDT. So there's a real risk of it being unconstitutional if we divert that process and create a separate disciplinary tribunal for just one segment of civil servants.
Coverage of the tribunal is not limited to disciplinary matters. Anything else in relation to the act?
The idea that we have is there's no appeal mechanism in the bill. The only one that you have is straight to the PS.
So for the employment related matters, as well as it goes through the ERA. So yes, the employment relations matters go through the ERA where there is a specific employment relations tribunal. For serious disciplinary matters, it's the PSDT. So there are already 2 existing tribunals. Our position is that those are sufficient. For the disciplinary matters, it's constitutionally through the PSDT, and for general employment grievances, it's the Employment Relations Tribunal, and that has an appeal and structured framework under the ERA. We also heard submissions that a lot of things for employment generally are not covered in the bill for teachers, but that's because they fall under the employment relations framework.
If somebody wants to appeal a decision by the permanent secretary, register school, deregister school, anything, where do they go?
They have the
Do
option
they have
of
to go
JR.
to court?
So a decision of the permanent secretary, because it's an executive decision, it would be judicial review under Section 15, I believe, of the Constitution.
That kind of a case, would it be better to have a tribunal rather than getting them to spend all that money to go to court
So
on those kinds of issues, not the HR issues?
so not employment, HR, general issues, but specific to decisions of the permanent secretary, general decisions around school registration. So the standard framework is judicial review because it's not really an appeal; it's an application for review, so that matters. It's whether the process was followed. So that's why JR and also the expertise around JR is developed. We are cautious of creating too many entities in the law because it may result in overly bureaucratic systems that struggle to function. But our position is that JR is a completely adequate remedy. In the interest of time, we note that a few of the remaining matters are actually minor or technical because they are pointers that we noted where, like, for example, asking for a definition where a definition is already provided, or ask. So all those minor technical matters, perhaps we'll just submit it in writing.
I'm sure you are well aware of the submission by the FTRE. Are there any comments on that submission? Because according to their submission, when they appeared before the committee, you totally disregarded their submission, the FTRA. Yeah. Any comments on that?
They were not disregarded. All of the submissions that were approved were included. For example, the CEO which is why I refer to it as minor technical matters. The submission was that the position of CEO, well, it is in the Act. We did put it in the Act, in the bill. So if the position of CEO is provided for there. There was a request, I mean, since it's brought up, there was a request for the CEO to be responsible for issuing all the licenses but our position on that was, so what we did was we created the option of delegation. So we put in a clause allowing the board to delegate, so that because the board is the representative of this body, the board is responsible for this body. So they may delegate to the CEO to do the licensing. So we provided a clear pathway in the law by putting in the delegation power. But the control over that should still remain with the board. So it's their decision whether or not, because of operational difficulties or maybe there are too many applications, it's their decision to delegate that to the CEO rather than directly giving that power to the CEO. Because if the law were to directly empower a CEO to take on the main function of a body or one of the main functions of a body, that may result in governance disruptions within the body itself, which is the CEO, who normally would report to the board, would be empowered by law to do things directly. So that's why, for better governance, the current preference is to instead just empower delegation and not directly empower an operational position. We also have put limited authority in the bill, so the limited authority to teach has been provided for. And a lot of these issues, we would note that they are provided for in the bill. Some are really minor technical. For example, the body is provided, the CEO is provided, it's empowered in the provision, but there is a preference to have also a definition in the definition section. But we only define something if there's a likelihood of confusion, or if people are unsure what this would mean. But the CEO, we are of the view that it would be clear to anyone reading that part that this CEO is the CEO. So we don't put in definitions unless there is a likelihood or a possibility of confusion. So these things are provided, but they don't always have specific definitions like the definition of CEO. And we can... for the fines are the current fines, so we did not increase fines. We thought that the framework there was reasonable. There is also a submission requesting that there be provisional and conditional registration pathways, but that has been put in the bill. There's limited authority to teach, provisional registration, and full registration. They're all laid out in the bill. We also probably, for higher education, a majority of the submissions in relation to higher education are things that are actually not in the current Act. They are things that are in the current regulations. So there is a full intention to develop regulations to sort of like, when it's the regulation making phase, to go out for consultations on how to develop those regulations. But for the Act itself, we do not think that it is appropriate to go into the regulations and at this stage just pull things from the regs and put it in the act, because when we went out for consultations, people were of the view that we were reviewing the act, so people did not have the opportunity to give us their feedback on the regulations, of which there are a few. So that's why the regulation making phase will be its own consultative phase, so that people can zero in on the regs and make their submissions. So we're not going, our recommendation is to not directly lump that all in the act right now, allow them to go through their own process for review of the regulations.
Anything from honorable members?
Curriculum body, the way that it's written now does not give it any stuffing. It just says do anything
Yes.
to what's the word that word is, make it operational.
Yes. Yeah.
Is there merit in putting something specific about they having the right to put stuff in and all that? Or is it adequate as it is?
It can be done by way of regulations, but also we were of the view that it was sufficient to have that clause and to allow the authority to determine their own framework. Yeah. Not all of statutory entities in laws have that full-fledged framework, because sometimes they perform only a specific function or a specific function that may not require a full staffing. So sometimes how it's done is it's secondment to give them the staff. A few of the boards under different laws provide for secondment rather than just directly mandating staff. And we want to give that body the flexibility to determine its own framework. Yeah. Oh, sorry, just one last issue. The Examinations Act, we heard submissions asking why the Examination Act was not included. So the Examination Act does not only cover school examinations. It also covers civil service examinations, which was something that they stopped doing for the longest time, but it's been brought back. But it doesn't just cover the school examinations. So when we reviewed the Examination Act, the penalties were sufficient. They're around 2,000. They're aligned to many of the penalties we were already putting in our bill. So we did not see any substantive changes we would be making to the Examination Act. And if we were to do it, it would still exist, but we would carve out only the school aspect and then leave behind the civil service aspect. And we were of the position that was a bit of a clumsy way to do it when that law currently has sufficient penalties. So the only reason we would include it and do that carving out exercise is just to have everything in one place. So it's more by form rather than substance. So
The flips is coming up. Why don't you take it out of that and plug it in flips?
Oh, yes. Yeah. So we'd have to do a legislative exercise of carving out, but we didn't have any substantive changes to the examination provisions themselves. So we were like, it would just be a matter of form. Whereas the laws we amalgamated or consolidated in one law, we had substantive changes to those as well. So we only prioritized the laws that we have substantive changes for.
And if I can just add, I think when the FLIPS Act was drafted, I wonder if the Examinations Act was considered during that review process. But if anything, amendments would be required anyway.
Okay, thank you. Thank you, honorable members. Please join me in thanking our submittees today. I'm mindful of the time that we have. We have another submission team coming. On behalf of the Standing Committee, we thank you for coming in this afternoon. Very good deliberations, but please be on standby if we need you to come again. There's a lot of things that we have discussed. We need to air it out. We need to find the balance. This is a big challenge. Let's try and get this bill to last at least for 10 years. Then they make a review. You know, that should be our goal. But I echo the voices of my colleagues here in the committee, and we thank you very much for coming in. We thank you for actually joining us in the public submission during our trips, 5-week trips around the country. So without further ado, thank you very much for coming in this afternoon. Naka.